Good afternoon, everyone, and welcome. This is the 2016 Benefits Update. Thank you for joining us today. Just to be clear, this will be a repeat of the session that we presented at the October 26th Employment and Labor Law Seminar, with a few updates for things that have changed since then. A few housekeeping items. Just to remind you that registration is still open for the December 13th Employee Absences, Restrictions, and Accommodations webinar. Ann Redolinsky and Ashley Thronson will be presenting. More information about that webinar can be found at fredlaw.com/events. We have also submitted for HRCI, SHRM, and Iowa and Minnesota CLE credit. We will send out the credit information to attendees in a follow-up email. Also, if you have questions, if you hover over the bottom of your screen, you should see a menu that has a Q&A option. If you type in your question, we will print it here and we'll answer at the end of our session. My name is Debra Linder. I'm the chair of the Compensation Planning and Employee Benefits Group, and I'm delighted to be joined today by my colleague, Thomas Henke.
Thank you so much.
Switching to our agenda, these are the topics that we'll be talking about today. I'll kick it off by talking about the new fiduciary rules that were issued earlier this year. I'll then turn it over to Thomas to talk about some litigation and some trends in that area. I'll talk about some benefit trends that we've been seeing, and then Thomas will wrap it up with some updates on reporting requirements. All right, let's get started. So starting with the fiduciary rules, as you all probably know, the definition of fiduciary has been largely unchanged since ERISA was passed back in 1974. In 2010, the Department of Labor started looking at that definition and proposed regulations that would have greatly expanded who would have been subject to the fiduciary rules. The Department of Labor received a number of comments claiming that they went too far, so the Department of Labor withdrew those regulations, reconsidered their position, and issued final rules in April of 2016. To give folks time to read those new rules, digest them, prepare for them, the new rules go into effect on April 10th, 2017. In addition, there are certain provisions that affect contracts with your service providers. Those provisions are being phased in and will become effective January 1st, 2018. So let's start with a little background. As you all probably know, ERISA and the Internal Revenue Code imposes a variety of fiduciary standards and restricts certain kinds of transactions relating to 401k plans and other retirement programs. If those rules are violated, the fiduciaries can face personal liability, and it can also trigger various penalties. What are the duties that fiduciaries must follow? Well, they have to do a variety of things. They must act solely in the interest of participants and the beneficiaries of the plan. They have to act for the exclusive purpose of providing benefits to those folks. They have to act prudently. They must diversify investments. They have to follow the plan documents. And key for the discussion today is that they have to avoid self-dealing. They can't use the plan assets for their own profit. Many of the arrangements that you may have with respect to your 401k or other retirement program, you might have service providers that are being paid fees from the plan assets, and those fees that they receive must be reasonable in order to avoid violating the fiduciary obligations. Who is a fiduciary? The statute defines a fiduciary as someone who exercises discretionary authority or control over the management of the plan or its assets, has discretionary authority over the plan administration, or for purposes of our discussion today, renders investment advice for a fee. And that's the focus we're going to take today. That's what the new rules are really all about. What is investment advice? The new regulations define that as any advice provided by a person who meets one of three criteria. Either they acknowledge that they are a fiduciary, they provide the advice under some kind of written or verbal understanding or arrangement, or they direct the advice to specific individuals about whether they should be making the particular investment. That advice also must be provided for a fee, and it must be provided to a retirement plan, a plan fiduciary, a participant, beneficiary, IRA owner, or an owner of a health savings account. So the new rules largely expanded the group of individuals to whom the fiduciary rules will apply. IRAs and HSAs are generally not subject to ERISA, but folks providing services to those arrangements will be subject or could be subject to the new rules. With respect to HSAs, I would just comment that you'll want to watch for additional guidance here. I talked with the Department of Labor back in August, September, asking them how these rules would play out for health savings accounts, given that they generally aren't considered an ERISA plan. The employer often has minimal involvement with those programs. There's usually a bank custodian, but they're typically marketed through the health insurance carrier or a third-party administrator. The Department of Labor told me at that time that they would be issuing HSA-specific FAQs soon. We still don't have them. It's December. I'm not certain we'll have them by the end of the year, but I guess we can always hope, and we'll just have to watch for more guidance with respect to the health savings account. All right. What is investment advice? Back in the old days, I had some investment advisors claim that they were not a fiduciary because they were only providing, quote, recommendations about investments. Somebody else was making the decision, so they were not a fiduciary. Well, that doesn't work now. Investment advice now includes recommendations about whether you should buy, hold, sell various investments, recommendations about how to manage those investments, and the big change is recommendations regarding rollovers and distributions. This was a big change, particularly in the investment industry, because it means now that broker-dealers and various investment advisors are going to be subject to the fiduciary rules. What exactly is a recommendation? The regulations define that as any kind of communication that is reasonably viewed as suggesting that the person take or not take a particular course of action. The communication must be individually tailored, and it can include a series of communications. One statement might not be sufficient, but when you add that statement to the second or the third or the fourth, together those communications could be viewed as a recommendation. Reasonably viewed by whom? More than likely it's going to be the person receiving the communication. All right, with any good set of rules, there's all sorts of exclusions, and I'll highlight a few of those today, those that are particularly of interest to folks in the HR world. The first one relates to marketing activities. So the brochures and pamphlets and things that you might receive in the mail from investment advisors, record keepers, and the like, the hire me type of disclosures, that is not going to be considered fiduciary in nature. That's not going to be providing investment advice targeted to your plan or your plan participants. The same thing with sample investment lineups in RFPs. If you do an RFP for your 401k plan, the folks responding to that RFP may have a sample listing of the investments that they would propose for your plan, but it isn't tailored to your specific plan. So that would not be considered investment advice. General communications, investment education about the plan, how to invest, asset allocation, investment materials that are interactive in nature, the workshops that you might provide to your employees about how to save for retirement and invest their accounts, that's not going to be considered investment advice. And I think that's a huge exclusion for the HR folks. So the workshops and such that you're doing for your employees, you can continue to do those without triggering the new rules. Also, I think critical for HR folks is the exclusion relating to those employees who have to develop reports, maybe for the board, for the retirement committee, or have information that you provide to participants internally. All of that type of activity is not going to be considered investment advice and would not trip the fiduciary rules so long as you are not receiving additional compensation for performing those services. So what do you need to do next? As the plan sponsor, I think the next step is that you need to determine who exactly is a fiduciary with respect to your retirement program. And that could be a long list. You're more than likely going to have your board members, certainly the trustees, members of any investment or retirement committee that you have. Third-party administrators might be on that list, investment advisors. Again, it could be a long list. And then once you know who those folks are, take a look at the contracts that you have with those folks, certainly with your investment advisor, your third-party administrator, and the like. Are new contracts or disclosures required? Make sure that if they are a fiduciary, that they are acknowledging fiduciary status in that contract. Lately, we've been seeing some changes to the indemnification provisions, and many contracts have started to add arbitration requirements. Take a look at those provisions, review them with legal counsel, and make sure that they are adequate to protect your company. Should you have arbitration? Is it appropriate? Those are the kinds of questions that you should be asking. Also make certain and ask whether there are any changes to current services. Some record keepers in the past have been willing to provide an investment analysis of the funds that you're offering through their platform. But they may not be willing to do that now because it may be viewed as investment advice and would subject them to the fiduciary rules. If there are changes to those services, do you now need to hire somebody else to fill that gap? Do you need to get an independent investment advisor? Those are the kinds of questions you should be asking. And maybe it's time to consider an RFP. If you haven't gone out to the market, kicked the tires in the last few years, maybe it's time to do that. I know that it's a very lengthy process and an involved process, but sometimes it's good to test the market. Finally, take a look at your internal employee communications and your internal processes. Do you have any fiduciary risk with respect to what you're telling your employees? Where does that risk exist and how can we manage it? And whatever you do, make sure that you have a process and that you document it. Documentation is absolutely critical to withstand a Department of Labor challenge or withstand any challenges by participants. You need to have clear documentation about what you did and why you did it. So I've been getting questions lately about whether the rules will survive. In the past, there have been some lawsuits filed to challenge the new rules as being unconstitutional. There have also been a number of bills introduced in Congress, but so far no action has been taken on that front. With the election, who knows? I think it's possible that we will see these rules get tweaked. They might get withdrawn. It's hard to predict whether they will or won't survive. But I think at this point, the best you can do is move forward with assuming that the rules will go into effect in April and make sure that you're ready to comply, assuming they continue in existence. And with that, I'll turn it over to Thomas.
Thank you so much, Deb. Starting in litigation, I actually want to chat a little bit about a case that was filed after our October seminar for the employment law group, and that it has to do with AARP versus the EEOC and is about wellness benefit plans. Now, earlier this year, the EEOC came out with final regulations permitting wellness benefit plans that essentially provided a 30% reduction in your premium should you take part in the incentive plan. And the AARP has challenged that in court, those regs in court, because they feel that the 30% incentive, and that's on the single employee coverage alone, is too excessive to essentially be a voluntary benefit and thus would not be allowed under non-discrimination rules. That is an ongoing matter, and we really don't know where things will end up, particularly considering the, let's say, the lack of knowledge we have about what is going to happen to the Affordable Care Act. But if you are using wellness benefits to incentivize certain behavior in your health plans, you should be aware of that, and it will impact you next year. Now, litigation generally, the biggest trend we've seen in litigation in recent years has been with the 401k plan and excessive fee litigation. Traditionally, in the past few years, this has been with large plans, many with over $1 billion in assets and large-scale service providers. However, Given the relative simplicity of the cases, many benefits attorneys thought they were ripe for sort of descending into smaller mid-market and small market plans, and we are seeing that occur. This past May, right here in South St. Paul, near just south of St. Paul, as you'd expect, Lemitri's Collision Repair Shop had, with only $10 million in their plan, was sued for excessive fees. Now, I saw the complaint in this case. It wasn't beautifully drafted. They didn't really make a great case, but so the case was dismissed. But that doesn't mean that we shouldn't be aware that these cases on excessive fees can descend into smaller market plans. In Ohio, Checksmart Financial was also sued with respect to their pre-selected investment funds, which the plaintiffs claim had excessive fees on them as well. How do you protect yourself against this excessive fee litigation? First and foremost, the best protection you can get is an independent advisor looking at your fee structure and comparing it against market. Next, have an investment policy, and if you have that investment policy, make sure you follow your investment policy. Next, document your review process. It's not the ultimate outcome that matters. It's that you went through the process to check fees and then go on checking them over time. You need to see what the market is doing, and this isn't a duty that goes away once you make the initial analysis. Another major area of litigation we're seeing is in the 403B plan world. Colleges in particular, probably because the colleges that were sued earlier this year have large endowments. They are offering 403B plans that have multiple vendors underneath the 403B plan itself, and each of these vendors then has multiple funds. And at the same time, excessive fees in those. And it's not uncommon in the 403B plan world to see fees that are close to 3 times what you'll see in a 401k plan. For private colleges like these shown here, like Yale, Northwestern, et cetera, these are still ERISA plans, and you cannot, if you're a nonprofit, a private nonprofit that is in the 403B plan sphere, you are not exempt from the ERISA obligations to monitor the investments in your plan. So there are steps you need to take in reviewing the offerings in your 403B plan arrangement and negotiating as good a fee arrangement as you can given the 403B plan environment. It is possible to consolidate your vendors and bring down the excessive fees that you'll see out there in the world. And this issue of 403B plan excessive fees has received a lot of press recently, in particular actually in the public school realm. The New York Times did a series of articles this fall demonstrating how public school teachers are paying fees that are often 2 to 3 times as high as what we're seeing in the private world. It's basically something as a sponsor you should pay attention to make sure that your employees are not being taken advantage of by the financial service industry. Next, we're also seeing other types of fee arrangements being targeted. Float income, a few years ago, there was a challenge against Fidelity for keeping float income. That's the interest that is earned by funds when they shift between different investments, essentially an overnight interest payment, and Fidelity was keeping that without disclosing it to their plans. Well, they lost that case, and then they went and changed all their administrative service agreements to provide that the float should be retained by Fidelity, and that was common throughout the industry. That income is still being challenged as being reasonable. One of the reasons for that is because it's very difficult to determine what float income is going in to any contract. So we'll still see talk about this over future years. Secret profits from stable value funds. Stable value funds are a black hole in terms of fees. And there's a great case earlier this year against Great West Life and Annuity where they were accused of secretly manipulating the crediting rate in their stable value funds to basically make themselves more money. They suppressed the rate and kept the added profits. This is a very difficult issue to ferret out, and most of the litigation we're seeing is against the stable value provider themselves, but if you have a substantial employee base, it doesn't mean that you can't get caught up in it, especially if you have that stable value investment. Other challenges and fees. Vanguard funds, usually considered the gold standard of cheap funds, have been challenged as too expensive for a fund in California. This is a very large plan, a Blue Cross Blue Shield, it's called Anthem there, where they had Vanguard index funds that were charging about 12 basis points, and a collective trust fund, an ETF option, was available from Vanguard that charged only 8 basis points. Basically, the lesson we need to take from this is that there is no protection just because you have an index fund. Just because you think you have a low-cost fund, you still need to compare it against the market and what is available to you. As I alluded to already, stable value funds, guaranteed investment contracts all have a lot of litigation against them recently, basically because of the opacity of their structures. MassMutual, Cigna, all have been caught up in litigation. Investments in target date funds, particularly proprietary funds, have seen a lot of litigation over the past year. Often it's from in the financial service companies themselves. Morgan Stanley was sued by its own plan participants for offering a Morgan Stanley target date funds at too high a rate. But the important thing for any plan sponsor to remember when reviewing your plan investment options is that you need to look at all funds offered, not just the individual actively managed funds, also the target date, the default investment funds. More and more money is pouring into target date funds with automatic contribution arrangements, automatic selection of investments, and the failure to analyze these funds exposes any plan sponsor to a liability risk should they be deemed too expensive. So to finally get off of fee litigation, we have one more case, and it's about burden of proof, and it came out of California. It won't directly apply here, being a Ninth Circuit case, but it brought up a lot of issues that we think are important for plan sponsors to note. This case involved a gentleman, Barton, who happened to die in the midst of the litigation, who worked for ADT Security and one of its affiliates from 1967 through 1986, and that shift between the affiliate to ADT itself happened in the mid-70s. When he made that shift, he got a letter from ADT telling him that his prior service with the affiliate would be counted for purposes of his pension, but there was no other notation made of that. And he left the company in 1986, went on about his business. The company was bought and sold. The plan went through multiple record keepers. We come up to 2010. Now the plan is with Tyco International, and they get a request for a pension from Mr. Barton. And they apply what they think are the records they have, and it says that he only has 9 years of service. At the time, he needed 10 to get his full pension. And he goes, wait a minute, I was promised my full pension, and he sues for his pension. And he's able to produce this letter stating that he was going to be granted prior service. Tyco had no idea about any of this. and could not reconstruct any of this. But the court felt that because he was able to produce that, he could show, he met his burden of proof showing that he might be owed a pension. Now that burden shifted to the plan sponsor to show that he was not owed a pension. It can be incredibly difficult to prove the negative in these cases because we have shifts of record keepers and shifts of sponsors. Essentially, Tyco is going to be held liable for the full pension in all likelihood, and that will be paid off to his estate. But the lessons we need to take from this is that time does not excuse you from ERISA's requirements for maintaining records necessary to determine benefits. That obligation as a plan sponsor extends as far back as you need it to determine those benefits. So you need to maintain records regarding service through transition and maintain records about payouts so that you can prove that you actually paid somebody out and they aren't owed a benefit. Often you get requests for a benefit that occurs years and years after someone has left your company. Why? They often get a copy of a notice from the Social Security agency saying they might have a benefit in your plan even though you might have paid them out. However, if you've acquired that company or the plan that was originally the employer in this case, you might have no idea of the service that applied to that person and have no way of actually reconstructing whether or not any benefit was paid. So you need to, when you acquire companies, you need to make sure you're getting records about vesting of the employees, whether they were actually eligible and whether they were paid out. And you also need to note that new record keepers, when you make a record keeper transition, may not be entirely happy with helping you with this process. In particular, they often like to sweep accounts into fully vested accounts and just reduce their amount to reduce records of record keeping costs for determining who is vested at what level. This is I would say, an ongoing concern that all sponsors should take seriously when they are looking at changing record keepers and maintaining their own records. It's also not a bad idea to maintain those records of payout independently from your record keeper who might not be paying attention to what your prior record keeper was doing. And that's all I have on benefits litigation for now.
All right. Thank you, Thomas. On that last point, as I've often told my clients that they should resist the urge to purge when it comes to pension documentation, because you never know when you're going to need that information. All right, let's switch gears and talk a little bit about some of the trends we're seeing in the benefits area. And the first one that I would like to talk about is telemedicine. I know that a number of you have either considered this or may have added it to your benefit package. This, of course, is where someone can sit at their desk and receive medical care either via the internet or by phone. They may be getting a consultation, diagnosis, and maybe even a prescription or other kind of treatment. That type of an arrangement is, of course, a group health plan under the Department of Labor and the IRS's rules. So that raises several legal challenges that you would want to keep in mind when you're structuring these types of benefit programs. For example, this group health plan would have to comply with the Affordable Care Act mandates. How will you do that with your telemedicine program? One way that has been proposed is to integrate it with your other group health plan, and that's probably a very good way to make sure that you're in compliance. The trick, though, is that you have to limit that program to only those folks who are actually enrolled on your group health plan. You could not make the telemedicine program available to others who choose not to enroll on your group health plan. Could you structure it as an employee assistance program? Maybe. Here, in order to be exempt from the Affordable Care Act, the EAP cannot provide, quote, significant medical care, can't be coordinated with another group health plan, and can't be provided at any cost to the employee, so essentially free to the employee. That may or may not work with your telemedicine program, particularly since we don't know what significant medical care might be. Could it be a voluntary employee-paid plan? Possibly. Here, though, the employer could not make any contribution, and typically the employer wants to help employees pay for some of these charges. The employer could not have any other involvement or endorsement of the program, and participation would have to be completely voluntary. It seems to me probably the best approach is to integrate it with your other group health plan and simply make it available to those folks who are actually enrolled. And when you do that, make sure that you take into consideration any design issues you might have if you are a high deductible health plan with an HSA arrangement. Remember that employees cannot make or have made on their behalf HSA contributions if they have other health coverage. So it will be very important to carefully coordinate the design of the telemedicine program with the design of your high deductible health plan HSA arrangement. The next one that I want to talk about is the opt-out credits. The IRS recently issued some guidance with respect to opt-out credits and whether those count for purposes of determining if your health coverage is affordable. Opt-out credits are essentially cash payments that you might make to employees if they choose to waive your health coverage. The IRS views those cash payments just like a salary reduction. In the eyes of the IRS says, well, the employee has foregone the opportunity to get that cash. Therefore, that's a cost of the coverage that the employee has chosen to take and should be considered as part of the cost of that coverage when you're determining whether your premiums are affordable under the Affordable Care Act. They don't have to be counted, however, if the opt-out credit is conditional. And the opt-out credit would be conditional if it meets a variety of conditions, as you might expect. One is that the employee must waive coverage. That's fairly easy. The second one, however, is that the employee must provide reasonable evidence that the employee and all of the employee's tax dependents, spouse, children, etc., will have minimum essential coverage other than individual coverage, so essentially other group health coverage like the spouse's plan. And if the employee provides that evidence, then you can pay the opt-out credit to the employee and not count it as part of your cost of coverage. However, you can't pay it if you know or have reason to know that the employee or these family members don't have the coverage. Well, I don't know how in the world employers could ever be expected to police that. So it seems to me at the end of the day, we're left with probably having the employee sign a statement that says they waive coverage and that they attest and confirm that they and all of their tax dependents have minimum essential coverage under another group health plan. And then you would obtain that statement on an annual basis, typically during open enrollment. A few other trends that I'm sure you're seeing in your organizations as well. On this list, I wanted to focus in on student loan repayment programs. Younger employees today may have sizable student loans that they have to repay, and some employers are trying to help employees make those payments. We had been seeing some matching programs where employers would say, if you make your loan payment, we'll match it and make another one for you to help you get that loan paid off maybe a little faster. The new twist is with respect to the 401k or retirement plan. Some employers have considered saying to employees, well, we understand that you've got limited resources. You have to make a choice. Are you going to repay your student loan, or are you going to save for your retirement? I know you can't do both. So if you make your student loan payment, we're going to make a contribution on your behalf to the 401k plan. And that sounds wonderful, except I would suggest that you talk with your benefits counsel if you're looking at implementing that kind of a program, because I can think of a host of issues under the IRS and the Department of Labor rules that might come into play with the design of that kind of program, discrimination testing and the like. So stay tuned for that, but if you are thinking about that, give one of us a call. And the last one that I'll talk about is state-run IRA programs. Several states have adopted what's called a sort of a multiple employer program, if you will, for small employers to make this arrangement available to their employees. This would be for employers who do not otherwise offer a retirement plan, and these programs are not subject to ERISA, so long as certain conditions are met. Again, essentially, it's an avenue for employees to save for retirement on their own. The conditions that the Department of Labor has imposed generally include things like the state must control the investments of the arrangement. The state must monitor the payroll contributions and make sure that they're timely provided. The employer cannot make any contribution at all, and participation has to be completely voluntary. If those safe harbors are met, if those conditions are met, then the IRA program is not subject to ERISA, and it would be simply, essentially, kind of like a government-run program. Other states may be considering this type of an arrangement. I have not heard that Minnesota is thinking about it at this point, but you never know what might change. And again, with the election, hard to know whether this will continue or whether this will go away. So more to come on that, but again, wanted to make you aware of this trend as well. All right, Thomas, I'll let you wrap it up with reporting requirements.
Okay. Reporting requirements also involves notification requirements, and with respect to that, the failure to provide those notifications. One of the big changes we've seen here is the Department of Labor's increase in penalties for failing to meet your disclosure notification requirements. A lot of these really come up upon audit because plan sponsors aren't necessarily aware of their errors, but they can add up very quickly and amount to extreme costs for any sponsor who isn't paying quite enough attention. Notice small things like failure to provide benefit statements. $28 per employee per day. If you fail to file your 5500, the fee for that has doubled from just over $1,000 to $2,063 per day. So that can add up very quickly, and especially if you have a plan that you weren't aware you were supposed to be filing a 5500 for, and that error can go on over multiple years before you're caught, and thus lead to a very large penalty. Other common notices that we see, the automatic contribution notice, that's an annual requirement. The failure to do it, $1,600 a day, can begin to bite quite a bit if you're caught. Blackout notices, summary benefits coverage, the Children's Health Incentive Program notice, all of them have increased penalties. Another issue is the compliance with the Genetic Information Non-Discrimination Act. We have seen increased action by the Department of Labor on this, and they have increased their minimum penalties for failures on this. And by the way, this is just a minimum. We have, over the past year and a half, we've seen multiple cases where the Department of Labor has assessed very steep fines for this, often in the millions, for failure to properly handle genetic information. Another major change we're seeing is the proposed 5500 changes. Now this is not effective yet, and they're not looking at doing this for a few years, and who knows what the the future administration will do to this. But the idea is to modernize the 5500 and to bring it in line with other disclosures required for your benefit plans, in particular fees and expenses, the ERISA 408B2 and 404A5 disclosures. So bring information in the 5500 in line with those separate disclosures. The other major change we're seeing is in the proposal is to now require all group health plans to file 5500s. If you've got a small group health plan with under 100 participants, you've enjoyed the exclusion from the 5500 for filings if you were an insured plan, and that will go away if the proposal that is currently out there goes forward. And that means new questions about plan operations, your service provider relationships, financial management of your health plans beyond the work you're already doing on your retirement plan. Outside of the 5500, we have the Affordable Care Act changes. Now, this slide was prepared before November 18th when the IRS gave us an extension. So it talked about keeping the deadlines that were originally in place. Now we have a bit of a change here. Your 1095 B and C. The 1095 is the notification from the insurer. The 1095-C is from applicable large employers for their health plans. And that has been extended from January 31st to March 2nd, 2017, an automatic extension. You don't have to file anything with the IRS to get additional time here. However, they did not extend the 1094 B and C requirements, which were when you had to provide the copies of those 1095s to the government. So those don't get the extension, but you do have the opportunity to file for an extension if you need it on the government disclosure. Another very useful thing that came out of the November notice from the IRS is they did extend the good faith compliance exemption from penalties. So you can essentially do your best job and avoid major penalties from the IRS for any failures that occurred. So that is very, very welcome relief. But it's important to remember here, despite all of the essentially noise we hear from Washington about repeal and what is going to happen with the Affordable Care Act, that these reporting deadlines are still in place, and you still have an obligation, if you're an applicable large employer, to provide these statements to your employees. One other change that happened post our seminar was the 2017 cost of living adjustments occurred for qualified plans. We did provide an alert on our website for that, but the gist of it is that your 401k deferral, the employee contribution portion stayed the same at $18,000 with $6,000 catch-up, but the annual contribution maximum bumped up $1,000, and the compensation limit bumped up $5,000. The Social Security taxable wage base also had a significant bump. So when doing your calculations for 2017, make sure those changes are taken into account. And now we have some questions, I believe.
Yes, we do indeed. And I'll start with a couple of questions that I have on the opt-out credits. The first question is whether we, Fredrikson and Byron, can provide a sample of the form that employees who are opting out of the medical plan should sign. Absolutely, we can help draft that. There isn't a particular format that the IRS requires, but we can certainly help you design or come up with a form that you can use for your employees. So we would be happy to do that. The second question relates to a situation where open enrollment has already passed, and you've had employees who have waived coverage but didn't have a form that they signed, of course, attesting that they had other coverage, and whether the employer should go back and do so now. And I guess my advice would be yes, unless you can be certain that when you factor in the opt-out credit into your premium cost, that your health coverage is still affordable. If it's still affordable, taking into consideration the opt-out credit, you wouldn't necessarily have to go back and get a form signed by the folks who waived coverage. But if you're on the cusp, or if it's possible that your plan would not be considered affordable, I would go back and ask the employee to sign that form. The final part of the question relates to whether if the employee does not have coverage under another plan, can you force them into a basic plan or maybe on the exchange? And I guess my answer to that question, Thomas, I'll let you chime in if you'd like. Forcing someone into a basic plan, I don't think you necessarily can do that. I mean, it's really the employee's choice. So,
yes.
Yeah, I don't see a way to kind of force them to take coverage if they don't want it.
No, I don't. I can't think of anything.
I can't think of any way to do that. Yeah, but be happy to talk offline if you'd like to explore that further. Okay.
And then we had another question regarding the notices and the penalties, and can the penalties for not communicating the required, how far can the penalties for not communicating the required notices go back? And how far back would DOL audits go? As a general rule, ERISA has a statute of limitations for 6 years plus the time it takes to file the 5500 for that year, so you get almost 7 years out of that. And the DOL can go at least that far back, though occasionally you'll see DOL auditors who look further back than that and assess a penalty during the statute of limitation periods for older failures. So say you had a failure that occurred 10 years ago that was never corrected. They won't be able to assess you a penalty all the way back 10 years, but they'll go back there 6.5 and assess it forward from there. So some of these penalties do have cumulative limits that can bring back some of the costs a bit. Generally, the point is that they are increasing these penalties to scare you into voluntary compliance, which often, quite frankly, is a very good deal. So if you discover through routine audits that you've had some issues on failure to disclose information, it's not a bad idea to consider going in to the government and saying mea culpa and taking the slap on the wrist rather than rolling the dice and hoping that the government never catches you.
Okay, so I have another question here about whether the topics discussed today apply to employers with less than 50 employees. And this employer also provides a simple IRA with a 3% match, which is done through a broker. So I guess I'll start with respect to the fiduciary rules. If you have a simple IRA program, more than likely you have limited involvement with that program. You're making your matching contributions. You're perhaps setting employees up with IRAs. You have a broker, obviously, that's involved in that process. And that broker would certainly be a fiduciary with respect to your simple IRA program. I'm not thinking of necessarily any way that the employer would become a fiduciary in that scenario. Thomas, would you agree with that, or do you have any other thoughts?
No, I think if you're limited involvement, no, you're just fine.
Right. As to the other topics, like the Affordable Care Act, if you have fewer than 50 full-time and full-time equivalent employees, then you do not have to comply with the Affordable Care Act with respect to the employer shared responsibility requirements. However, the other Affordable Care Act requirements that affect the design of your health plan, for example, coverage for dependent children to age 26, eliminating pre-existing condition exclusions, annual and lifetime caps have to go. All of those design type changes, those do apply to your health plan. And so when we're talking about telemedicine, that would come into play. If we're talking about opt-out credits and whether that factors into whether your health plan is affordable, that would not come into play because you're not subject to the shared responsibility rules. But Thomas, do you want to comment about the other things that you talked about, the fee litigation and reporting?
With regard to fee litigation, for the most part, if you're not going to be choosing investments for the participants in this plan, you will probably be exempt from it. However, your providers very well may get caught up in it, and thus it would affect your employees through that route. So it doesn't mean that it goes away completely. And obviously, if you're having any sort of more significant role in choosing investments, the investments offered under a plan, frankly, choosing the provider themselves, you might still consider this litigation as just a warning for what not to do.
Mm-hmm. I would agree with that. All right. We have one more question that's coming, so if you will bear with us for a second. In the meanwhile, I'll just remind you again that you can still register for the December 13th Employee Absences, Restrictions, and Accommodations webinar that will be presented by Ann Radolinsky and Ashley Thronson. And more information about that can be found at fredlaw.com/events. If you do have questions, please type them up and we'll get them hopefully answered for you. Oh, this is the same question. Yep, so I'm sorry. So we answered that already. It's the same question about the 50 employees or less.
And I don't know that I have any different answers.
I don't either. So it was a trick. Any other questions from the folks attending? Yep, we answered that, yep. Okay.
All right.
Well, if no other questions, we can
probably wrap it up.
We can wrap it up and let you get back to your day. We do thank you for your time and attention today. And if you do have any other questions that come to mind later, feel free to contact either Thomas, Henke, or myself.
And we promise that next year will be full of surprises.
Well, if nothing else, there's always change, right?
All right.
All right, very good.
Thank you,
Thank you
everyone.
all.